especially if they're small or without fresh air. Proximity to other people is also important. It's safest when there are fewer people around and you can keep more than 1 meter apart. How long does your activity last? The shorter, the better. Think about each of these factors and avoid situations where the risk dial is high. Small or poorly ventilated places and crowds of people for long periods of time. Stay safe. Lower the risk to yourself and others.
And allow us, bless Jamaica land we love, and we thank you for all the blessings we've received thus far. In your son's name, amen.
Amen. Thank you. Okay, so welcome again to this meeting of the Joint Select Committees to consider the bill to repeal and replace the customs. I'm just adjusting my laptop here. It's a little bit lopsided on my desk. We have been making good progress over the past few meetings, and I hope we'll make similar progress here today. I don't know if we have any apologies for absence, Ms. Bailey.
Yes, Chairman, we have an apology for Member Robinson. He will be absent.
Okay. All right, so the minutes of the meetings, last week's meeting was circulated. Do we have any proposed amendments to the minutes? And if we don't, can we have someone propose that the minutes be accepted?
So proposed, Minister.
Thank you, Senator Allen. Seconded by?
I will second, Minister.
Thank you, Senator. All in favor?
Aye.
All right, thank you. Any matters arising from the minutes to deal with at this meeting?
Chairman, I wasn't at the meeting last week, but I've gone through the minutes. And just to reiterate a point that has been made, I think the issue on clause 155 on maintenance and warranties and duties and charges, and whether those should be charged, I think it's a substantive matter that needs some further consideration. And I hope that we'll have that going forward. That's my only comment.
Right, okay. All right, if there are no sort of matters arising, we will resume the clause by clause analysis, and I believe we start on clause 204. Who's going to do the honors for us this week?
We do start, Chairman, clause
204.
Yes.
Okay.
Is it 204?
Yes, Minister, it is. I will be reading today. I'm just seeking to finalize being able to project, to share my screen. If you would just give me a moment, Chairman. I sense.
You're not able to project?
I seem to be having some difficulties.
All right, can someone else project for you? Okay.
You're at clause 204?
Yes.
Right.
Clause part 12, security for payment of duty and other amounts payable to the commissioner, to commissioner. Clause 204, when security may be required. So clause 1, the commissioner may require security, A, for the payment of any duty or tax that is or may become payable under this act or any other customs law. B, to ensure the collection of any amount payable to the commissioner other than as described in paragraph A. Or C, for the fulfillment of any other obligation of a declarant or other debtor in relation to any requirement under the customs laws. 2, security referred to in subsection 1A may be required from any one of the following persons in respect of goods: A, the declarant, or B, any other person who may become liable to pay an amount to the commissioner in respect of the goods. 3, security referred to in subsection 1B may be required from a person who is or may become liable for the payment of the money owed to the commissioner. 4, security referred to in subsection 1C may be required from a person who is or may become liable for the fulfillment of the obligation. 5, another person may provide security on behalf of a person from whom security is required under this section. 6, the commissioner may require security referred to in subsection 1 as a precondition for or at any time subsequent to A, the release of goods for a customs procedure, B, the issue or renewal of an authorization that the commissioner is empowered to grant under this act, or C, any exemption that the commissioner is empowered to grant under this act. 205, determination of amount of security. 1, security for the purposes of this subpart shall be determined on the basis of risk. 2, when determining the amount of security required under section 204, the commissioner shall take into account all relevant factors, including A, an assessment of the risk to the revenue and the monetary extent of that risk to be covered by the security. B, the record of compliance with customs laws and duty and tax obligations of the person required to give the security. C, whether the person required to provide the security has certified status, and if so, the level of the certification. D, the annual turnover of the business of the person from whom the security is required. E, whether the person from whom the security is required is licensed or registered under this act. And F, such other factors as may be prescribed by rules. 3, if for any reason there is a change affecting A, the risk in relation to the payment or recovery of the duty, tax, or other amount, or B, the fulfillment of the obligation in respect of which the security was provided, the Commissioner may require the person from whom the security was required to alter the form, nature, or amount of the security, or to renew the security as the Commissioner considers appropriate. 4. Where security is required to be provided in respect of the payment of duty, tax, or other amounts payable to the Commissioner, the amount of the security required shall not exceed the amount that is payable. Clause 206, form of security. So clause 1. Security provided under this part shall be in the form of a bond issued on behalf of the person required to give the security. B, any security allowed under an international clearance arrangement. C, a cash deposit or any other equivalent means of payment acceptable to the Commissioner. Or D, such other kind of security as may be specified by rules. So clause 2, no interest shall become payable by the Commissioner in respect of any security provided under this Act. So clause 3, security in terms of subsection 1 shall be either A, a security relating to a single transaction, goods declaration, or customs procedure, or B, a comprehensive security to cover any duty, tax, and other obligations relating to 2 or more transactions, goods declarations, or customs procedures. 4, rules may prescribe the requirements to be satisfied by a comprehensive security for the purposes of subsection 3B. 5, security under this part and all documents accompanying the security shall be given in such form and manner and contain such particulars as may be prescribed by rules. Clause 207, utilization of security. 1, security provided under this part may be utilized for the payment or recovery of duty, tax, or other amounts owed to the Commissioner, or the fulfillment of any other obligation in respect of the matter for which the security was given. So clause 2, subject to subsection 1, the Commissioner shall return a security to the person who provided the security if A, the validity period of the security has expired and the security was not utilized under subsection 1, or B, the purpose for which the security was provided has lapsed and cannot be revived. Part 13, enforcement.
Chairman.
Please go ahead.
Madam Lawyer speaking. Just want to know that this idea of security based on risk is actually a departure from what now happens, and in fact, a trade facilitation measure. Prior to this, security will be based on the full duties that will be payable.
No, and this, thank you for pointing that out. And you're absolutely correct. This is with a view to improving Jamaica's standing in trade facilitation. And I think we discussed this at the last meeting with respect to another point. The general move with respect to, certainly with government authorities around the world with respect to various subject matters, such as AML and so on, where in order to be effective, doing so on a risk basis is seen as the most effective means and the most efficient means, rather than having everybody be subject to a particular requirement. That requirement is brought to bear based on the risk that that the situation poses. So thank you very much for that. Please continue.
Chairman, it is my hope that the rules to come will further refine the conditions and factors to be taken into account in both the risk assessment and the amounts, the assignment of the amounts to be charged.
Yes, for sure. Please continue.
Part 13, enforcement. Subpart A, recovery of debt. Clause 208, sums owed to commissioner recoverable as debt, excluding de minimis. Subclause 1, subject to subsection 3, money owed to the commissioner under this act.
Sorry, Mr. Chairman, down here. Sorry, I think I've missed it, Hazel. 206, when we're speaking about the form of the security, and we speak about a bond issued on behalf of the person, any security allowed under an international clearance arrangement. I assume 206B means like a letter of credit, irrevocable letter of credit. Is that the thinking behind that note, 206B? Because I know when you're clearing goods, and as a business person, sometimes you, or all the time, you don't want to tie up your cash. So you enter into an arrangement with a reputable commercial bank to issue a standby LC or some sort of an irrevocable LC to customs. I'm just asking the question for clarity. Is that what 206B means?
Not at 206 subclause 1B. That would perhaps be considered more in keeping with D or perhaps A in terms of bank guarantees that are issued.
Okay.
But what is considered at 206.1b would be the types of documents that are issued under what we call the ATA Carnet system, which is an international clearance arrangement.
Yes.
And in that case, it's an international organization that is providing the security. So that is what is contemplated there at 206B 1B.
Okay, I guess the mere fact that I asked the question is not very clear to me, because a letter of credit and a standby letter of credit is the most common financial instrument used as a security in trading. So I'm not sure how that will be dealt with, Mr. Chairman, or it is implicit in what Hazel just said.
Well, I know you've directed a question to the chairman, but it would be because we recognize that there are different types of instruments that financial institutions may develop over time. And so that is why 206.1d referred to such other kinds of security. So it would allow us to accept anything that is part of routine and good commercial practice.
Okay.
Of course, the commissioner will, what is generally recognized.
Okay, all right, I accept that. So, thank you.
Yes.
Thank you, Hazel.
Please continue.
So we were at
208,
clause 208, and I will just read it again, the chapeau. Subject to subsection 3, money owed to the commissioner under this act, A, is a debt payable to the commissioner for credit to the consolidated fund, and B, shall be recovered by the commissioner in accordance with this subpart and any other applicable provisions of this act. 2, where costs or expenses are recoverable under this act by the commissioner from any person, the amount of those costs or expenses is a debt payable to the commissioner. Where the amount of duty or tax payable in respect of any goods does not exceed the amount prescribed in the regulations, no notice or demand shall be given, and no action or proceedings to recover that duty or tax shall be taken under this Act. 209, recovery of debt, excluding de minimis. 1, a debt may be recovered from A, the person liable for the debt, or B, any security covering that debt. 2, where a debt is underpaid by an amount that is less than an amount prescribed by the minister, no action or proceedings to recover the underpayment shall be taken under this Act. 210, payment of debt in installments. The Commissioner may allow debt to be paid in installments, subject to such terms and conditions as may be prescribed by rules. 211, rate of interest.
I beg your
Interest
pardon.
shall-
I beg your pardon. I'm just trying to get a little clarification on 209, subsection 2, where it says where the debt is underpaid by an amount that is less than the amount prescribed by the minister. Unless I'm not fully understanding or appreciating, would you be able to just clarify that point? Are you in a position to?
Yes. What is contemplated here is that the minister would have the power to prescribe a particular amount. And if there is a debt that falls below that, then customs would not take action to recover it. So the idea is that there may be amounts that are so small that the cost, the administrative cost to the agency of pursuing the action would be more than the amount that's actually owed.
Okay, thank you, thank you.
In actuality, you're defining or giving content to the term de minimis, right?
Yes, indeed.
Okay.
Yes, indeed. And what it does is that it excludes, because the Commissioner would have a duty to recover every dollar that is owed to the revenue. And what this would do is allow the Commissioner to have a legal basis not to pursue what would usually be fairly small amounts.
Thank you.
Clause 211, rate of interest. Interest shall be payable at such rate as shall be prescribed by regulations subject to affirmative resolution, except as otherwise provided in any law. 212, establishment of accounts with Commissioner. Subclause 1, a person may, in accordance with such terms and conditions as may be prescribed by rules, establish an account with the Commissioner for the payment of duty, tax, and any other amounts owed to the Commissioner under this Act or any other customs law. 2, the Commissioner shall prescribe rules in respect of the management of accounts for the purposes of subsection 1. Clause 213, garnishment. Subclause 1. The Commissioner may act in accordance with subsection 2 in any case where the Commissioner knows or has reasonable cause to believe that a person A holds, controls, or has custody of money belonging to a debtor, or B is or will be within 1 year liable to make a payment to a debtor. Subclause 2. The Commissioner may, in writing, require the person to pay the money otherwise payable to the debtor in whole or in part to the Commissioner, A, forthwith, in the case of monies immediately payable, or B, in any other case, as and when the monies become payable. Apologies, I'll start again. B, in any other case, as and when the monies become payable on account of the amount owed by the debtor to the commissioner. 3, where the money required to be paid to the commissioner under subsection 2 is money otherwise payable to the debtor as interest, rent, remuneration, a dividend, an annuity, or other periodic payment, the requirement A applies to all such payments to be made by the person to the debtor until the amount owed by the debtor is satisfied, and B operates to require payments to the commissioner out of each such payment of such amount as is stipulated by the commissioner in the requirement. 4, a receipt issued by the commissioner for money paid by a person as required under this act is a good and sufficient discharge of the liability of that person to the debtor to the extent of the payment. 5, every person who, being required under subsection 2 to pay an amount of money to the commissioner, A, fails to pay that amount, in this section referred to as the unpaid amount, to the commissioner, or B, pays all or part of the money, in this section referred to as the diverted money, to a person other than the commissioner, remains liable to pay to the commissioner the unpaid amount or the diverted money, as the case may be. And the commissioner shall be entitled to recover that sum from the first mentioned person as a civil debt owing to the commissioner. 6, where a person carries on business under a duly authorized name or style other than the person's own name, A, notification to the person of a requirement under this section may be addressed to the name or style under which the person carries on business. And B, in the case of personal service, in addition to any other lawful means of service, shall be deemed to be validly served if left with an adult person employed at the place of business of the addressee. 7, where persons carry on business in partnership, A, notification to the persons of a requirement under this section may be addressed to the partnership name. And B, in the case of personal service, in addition to any other lawful means of service, shall be deemed to be validly served if served on one of the partners or left with an adult person employed at the place of business of the partnership. 8, except for subsection 5, the provisions of this section apply to the government of Jamaica in respect of A, money belonging to a debtor, which the government holds, controls, or has custody of, and B, any payment that the government is or will be within 1 year liable to pay to a debtor. 214, certification of debt. So clause 1. The commissioner may issue a certificate certifying the amount owed by a debtor to the commissioner that has not been paid, or any part thereof, as an amount payable by the debtor. 2, the commissioner may make an application to the Supreme Court, in this section referred to as the court, for an order to have registered in the court a certificate issued under subsection 1. Subclause 3, an application under subsection 2 shall be made in accordance with the applicable rules of court and shall be heard by a single judge of the court in chambers. 4, on a hearing under subsection 3, the judge shall make an order for the registration of the certificate in the court if the judge is satisfied that A, the commissioner is not restricted by section 215 from taking action under this section in respect of the amount owed by the debtor or any part thereof as certified in this certificate, and B, there are reasonable grounds for making the order, and it would not in the circumstances be unjust to do so. 5, a certificate registered under subsection 4 has the same effect, and all proceedings may be taken thereon, as if the certificate were a judgment obtained in the court against the debtor for a debt in the amount certified. And the rules of the court, including those provisions for accrual of interest, shall apply accordingly. 6. For the avoidance of doubt, for the purposes of this section, A, the rules of the court relating to judgment debts apply, and B, the commissioner shall be deemed to be a judgment creditor under those rules. 7. All reasonable costs and charges incurred or paid in respect of the registration in the court of a certificate or in respect of any proceedings taken to collect the amount certified are recoverable in like manner as if they had been included in the amount certified in the certificate when it was registered. 8. For the purposes of creating a charge, lien, or priority on property, whether real or personal, or any interest or right in such property belonging to a debtor, a certificate required to be registered under subsection 4 may be filed, registered, or otherwise recorded in any registry system, including A, the Register Book of Titles under the Registration of Titles Act, B, the Security Interest Registry established under the Security Interest in Personal Property Act, and C, the Record Office under the Record Office Act. In the same manner as a document evidencing a judgment of the court against a person for a debt owing by that person, or a writ of execution in respect of that debt, may be filed, registered, or otherwise recorded in that registry system. 9. If a certificate has been filed, registered, or otherwise recorded in a registry system under subsection 8 in respect of any property, or an interest or right in such property belonging to a debtor, a charge, lien, or priority is created on that property. Interest or right, in the same manner and to the same extent as if the certificate were a document evidencing a judgment of the court against a person for a debt owing by that person, or a writ of execution in respect of that debt. 10. A charge, lien, or priority created under subsection 9 by the filing, registration, or other recording of a certificate shall be subordinate to any charge, lien, or priority in respect of which all steps necessary to make it effective against other creditors were taken before the time the certificate was filed, registered, or otherwise recorded. 11. If a certificate is filed, registered, or otherwise recorded under subsection 8, proceedings may be taken in respect of the certificate, including proceedings A, to enforce payment of the amount evidenced by the certificate, interest on the amount, and all costs and charges paid or incurred in respect of 1, the filing, registration, or other recording of the certificate, and 2, proceedings taken to collect the amount. B, to sell or otherwise dispose of any property or interest or right in such property belonging to a debtor, and to effect the transfer of the title to such property, interest, or right in furtherance of a sale or disposition of the property, interest, or right. To renew or otherwise prolong the effectiveness of the filing, registration, or other recording of the certificate. D, to cancel or withdraw the certificate wholly or in respect of any of the property or interest or right affected by the certificate. Or E, to postpone the effectiveness of the filing, registration, or other recording of the certificate in favor of any right, charge, lien, or priority that has been or is intended to be filed, registered, or otherwise recorded in respect of any property, interest, or right affected by the certificate. In the same manner and to the same extent as if the certificate were a document evidencing a judgment against the person for a debt owing by that person or writ of execution in respect of that debt. 12. If a certificate registered under subsection 4 is presented to an official in a registry system referred to in subsection 8 for filing, registration, or other recording under that subsection, or a document relating to the certificate is presented to such official for filing, registration, or other recording for the purpose of any proceeding described in subsection 1, it shall be accepted for filing, registration, or other recording in the same manner and to the same extent as if the certificate or document were a document evidencing judgment against a person for a debt owing by that person or a writ of execution in respect of that debt. If access is sought to any person, place, or thing to make a filing, registration, or other recording referred to in subsection 12, access shall be granted in the same manner and to the same extent as if the certificate or document relating to the certificate, as the case may be, were a document evidencing judgment against a person for a debt owing by that person or a writ of execution in respect of that debt. Clause 215, limitation on actions under sections 213 and 214. So clause 1. The commissioner shall not take any action under section 213 or 214 in respect of an amount owed by a debtor unless A, the debtor has acknowledged in writing the amount owed, which may include by way of a goods declaration, and has not paid the amount. B, the time for making any objection or appeal in respect of the amount owed has expired and the amount has not been paid. C, in the event of an objection or appeal in respect of the amount owed, the objection or appeal has been finally determined in accordance with this act and the amount has not been paid. Or the amount owed has finally been determined by a court, otherwise than pursuant to an objection or appeal referred to in paragraph C, and the amount has not been paid. 2, the amounts in respect of which action may be taken by the commissioner under section 213 or 214 shall not include any amounts as determined by the commissioner that are payable to the debtor by the commissioner. 3, this section does not apply to A, any amount required to be deducted or withheld and required to be remitted or paid under any enactment, or B, any penalty or interest payable in respect of an amount referred to in paragraph A. 216, recovery by deduction or set off. So clause 1. Where an amount owed by a debtor has not been paid, the commissioner may require A, the retention by way of deduction or set off of such amount as the commissioner may specify out of any amount that may be or become payable to the debtor by the government of Jamaica, and B, that the amount deducted or set off be paid to the commissioner to be applied in reduction of the amount owed by the debtor to the commissioner. 2, the amount that may be deducted or set off under subsection 1 shall not include any amounts as determined by the commissioner that are payable to the debtor by the commissioner. 217, recovery as a civil debt, etc., without prejudice to any other remedies. Subclause 1. All duties, taxes, fees, charges, and other sums of money payable other than as a penalty imposed under a customs law may be recovered as a civil debt before a parish court without limitation of amount. A, at any time within 7 years after the sum becomes payable, and B, regardless of whether a fine on conviction or an administrative penalty is paid or payable in respect of an offense. So clause 2, the provisions of sections 213 and 214 are without prejudice to any other provisions of this act or any other enactment for the recovery of duty and tax owed by a debtor. Subpart B, investigations and powers of search, seizure, and detention. Clause 218, power of entry and search. So clause 1. The proper officer shall be entitled to enter and search any premises or other place in Jamaica, A, with the consent of the owner or occupier of the premises or other place, or B, in accordance with a warrant issued under subsection 4. 2, an officer who has reasonable cause to suspect that any goods, documents, or computer equipment to which this subsection applies are kept or concealed at any place in Jamaica may apply to a judge of a parish court or a justice of the peace for a special warrant in relation to such goods, documents, or computer equipment. Sub 3, subsection 2 applies to A, any goods in relation to which there is a contravention of the customs laws. B, any documents relating to goods referred to in paragraph A. And C, any computer equipment that there are reasonable grounds to believe, 1, have been used in connection with, and 2, to contain evidence relating to the contravention. 4, where on an application under subsection 2, the judge or justice is satisfied that the issue of a special warrant is justified, the judge or justice may grant the special warrant authorizing any officer named therein or authorized by the commissioner to A, enter and search the premises or place by day or by night. B, open the lock of any door, box, safe, or other receptacle which the officer has reasonable grounds to believe is relevant to the search, using such force as may be necessary. And C, seize and carry away any matter described in subsection 3 found at the place or premises. 5, a judge of a parish court or a justice of the peace may issue a warrant under this section only on the written application of the officer, setting out under oath or affirmation the grounds why it is necessary for the officer to grant access to the relevant premises or place. 6, where the matter seized under subsection 4 is A, computer equipment, that equipment shall be detained for not more than 72 hours, and thereafter shall be returned to the owner thereof, or the person or premises from which it was seized, as determined appropriate in the circumstances. B, matter other than computer equipment, that matter may be retained for so long as is necessary to retain it in its original form, in connection with the purpose for which the warrant was issued. But if the officer has reasonable grounds for believing that the matter, 1, may need to be produced for the purposes of any legal proceedings, and 2, might otherwise be unavailable for those purposes, the matter may be retained until those proceedings are concluded. 7, a judge of a parish court or a justice of the peace may, on application by the proper officer, extend the time allowed under subsection 6.
Chairman, sorry. Hi, good afternoon. On the matter that was just read, no, go back down with could you go back down a little bit, please? In terms of the non-computer items, they said that if the officer has reasonable ground, was reasonable ground, I mean, I understand what it means, right? But was it defined anywhere so that the arbitrariness of retaining those is not employed? So was reasonable ground defined in any of the terms, Ms. Edwards?
No, member, there is no definition in the Act of what will constitute reasonable grounds. In this respect, we're relying on what is, I think, well-established practice in the area of law enforcement as to what is reasonable. And of course, what is reasonable will depend always on the circumstances of the case. But there is, I would say, a fair body of case law in relation to it. And so if there is a challenge by an individual and the matter is adjudicated on a court will be able to determine whether there was reasonable grounds or not. What is expected in these circumstances is that, as you indicated, there should be no arbitrariness. The officer would ensure that there is at least some prima facie evidence to indicate that this information needs to be retained or would be needed. It's very difficult, I think, to have a precise definition of reasonable grounds.
While we're at it, may I just raise a question related? The provisions seem to, in this section, in the enforcement section, seems to, well, not seems to, it treats the decision or the powers of the judge and the justice of the peace as one and the same. And in actuality, they're not. And further to that, I mean, the justice of the peace situation in the context of Jamaica is one that, quite frankly, I've raised with it on many occasions concerns. The powers, as I look at the powers as you go along, and I'm enumerating the powers that are granted to the judge or the justice of the peace, it kind of rolls off very easily. But I think it is the case that most people will be comfortable with the judge, the parish judge, exercising a sort of review of the warrant, of these special warrants. The justice of the peace, I'll just say, I think it can be open to abuse. And I think I would be more comfortable, and I think the average business person would be more comfortable if the role for the justice of the peace was reserved for emergency situation, rather than a sort of generalized replacement of the parish judge. We understand and appreciate that the judge may be, their work schedule is long, but I believe in their current arrangements with the courts, there are parish judges that are assigned those kinds of duties, even on weekends, to be available in these circumstances. But I do, and maybe Don, I don't know if you have a view, if you wish to express, but the business community, as I understand it, understands that those wide powers given for search and seizure are really not to be taken lightly. If you were to compare that to what obtains in the court systems, not generally, I don't think those powers are widely available to justice of the peace. And yet, even though it's a custom enforcement, what is being authorized to really go into people's places and to seize, search and seize are really wide powers. So I would just caution that we give some thought to that. I would be more comfortable if the justice of the peace powers are reserved for exigencies, because there could be exigencies where the officer not being able to get a judge would need to have quick reference to. And I think that would be, that for me would be comfortable, but the generalized substitution of the parish court and the judge, I'm not comfortable with.
Yeah, Chairman, I thinking like Anthony Hilton. I think that's something that we probably need to discuss further. His analysis, I'm in line with it, and I think is pretty correct.
Can we hear from Customs on it?
Well, in relation to the matter of the Justice of the Peace issuing the warrants, this provision is not inconsistent with what exists elsewhere in terms of issuing of warrants for the police. And so we don't consider there to be a difficulty here. We also note that this mention was made of the availability of a parish judge to handle these matters. And so we do think it's appropriate to broaden the scope, particularly we're looking at an enforcement action that may require quick resort to the relevant judicial officer to have a decision taken on the warrant. We also are of the view that notice that this warrant is to be in writing, so it is not a verbal request. And so this elevates the request to a particular level. It means that the officer is not merely turning up to a justice and saying something and the justice is acting. The officer puts the request in writing, which also means too that if it is necessary later to scrutinize whether the officer had good grounds and the justice acted properly, there is that written application that could be subject of further judicial scrutiny. So we do note the concern, but we're of the view that it is not at all inappropriate to provide that the warrant may be granted by a justice of the peace alongside a parish judge.
Let me just do a quick response to that. In most instances where you're talking about the police, you're really talking about very serious crimes, and not just economic crimes, but you talk about crimes involving serious offense against persons. And so the exigencies that I mentioned, and I still reserve that, yes, there's a role for the justice of the peace, but to have, and I appreciate the point about the written warrant, or the request for the warrant to be in writing. But again, I make the point that the scope of the activities are far-reaching, touching on serious personal matter. When you talk about seizing computers and all of that, these are very, very broad-based and wide. And though necessary, I think judges are well trained and bring different levels of scrutiny and different levels of experience than justice of the peace generally. And I still say that it's a matter that requires some further consideration.
If I may, Minister. Minister?
Chairman?
Go ahead, please. Sorry about that. My thing was on mute.
Okay, yes, Velma Ricketts over here. So I note the members' concern, but wanted to include that this provision is certainly not new to how customs has been operating by utilizing justice of the peace. But I also want to say that the Justice of the Peace Act, Jurisdiction Act, does also empowers them the power to, summons or issue warrants. So I understand the need to look at the body that is the RMs, but I also want us to also understand that there is another body who would be able to perform the function, has been performing the function. Jamaica Customs in the past have not had any issue, have not had any court matter that anyone would have said that the justices would have operated outside of its role or were not satisfied. And it comes with the level of professionalism that is within that space. But there is a need in my mind that is required of the Justice of the Peace in aiding this issue as well. And I must also indicate that I myself is a Justice of the Peace, and it's not conflicting on myself. I just want you to know that as well.
Yeah, just I understand the concern, Senator Webby, Member Hilton, and against the background of Jamaica having the difficulties that we have with contraband and with corruption and so forth, for us to produce a new bill that constrains the power of the customs authority in the fight against corruption, when there is no complaint existing today, or that this power that they already have has been abused, I think would just be very problematic and send a wrong signal. This is the state accessing, a justice of the peace. This is not. I understand, concern about justice of the peace across the country, and individuals may, in the past, have, been able to abuse their authority or their power. This, however, is not some individual. This is the customs authority, who are accountable officers. If there is abuse, it can be brought up immediately. And again, this is a power that exists today, and there's no, to the best of my knowledge, there's no trail of evidence or of complaints that suggests that it has been abused. And I have a lot to answer for if I were to bring a bill to Parliament that constrained the authority of the customs agency in the fight against corruption, given where we are in Jamaica. We know that we have a problem with our borders, and with things entering, and with people not operating above board when it comes to dealing with customs. I don't see how I could, in light of that background, bring something that makes it harder for customs to fight against these kinds of activities.
Chairman, in that light, and I've listened to the discussion very carefully, I accept what you have said, and I am in agreement to leave as is.
My only comment is, Chairman, that the condition that you cited about corruption, that cuts in several ways, and I just caution, because the system we're putting in place now, the point has been made that there's been no complaint prior, but I appreciate that the system that you're putting in place now, including the rules, are much more robust, and perhaps we can, if you're so minded, we'll proceed. But I think you'll probably get some more tests along the way. But I simply raise for consideration, and not to prohibit anything. Certainly, not in the area of customs investigation, but so be it. But I raise a concern, but I'm not particularly wedded to.
Well, thank you for raising it. And I understand why you raised it. And thank you too for kind of seeing the context in which we're operating. And we have a lot of work to do at customs beyond even this legislation to ensure that, you know, we can have a safer Jamaica by being able to interrupt some of the nefarious activities that over a long period of time have taken place. Is it Mr. Foreman? Who had raised their hand, Ms. Bailey? Mr. Foreman?
Yes.
I can't see all the hands. Oh, yes. Please go ahead.
All right, Chairman, on this question, I just wanted to flag that there have been some recent developments in the case law in Jamaica regarding the powers of search under a warrant. And we may need to give consideration to adding some provisions dealing with, for example, legal professional privilege, express requirements in the legislation to address those types of scenarios. I would like us to, the chambers, to be given some time just to consider the matter somewhat, but I thought it important to flag it as a potential issue for consideration.
The legal professional privilege.
Yeah. Yes, there have been recent developments in case law regarding what statutes need to do in order to ensure consistency with that principle under the charter regime that we now have.
Please do. All right, Ms. Edwards, let's continue.
Chairman, she's muted.
Apologies.
Oh.
7. A judge of a parish court or justice of the peace may, on application by the proper officer, extend the time allowed under subsection 6A for the detention of computer equipment, if satisfied that the continuation of the detention is necessary for the purpose of an investigation of an offense or any proceedings for an offense under the customs laws. 8. An officer shall issue a receipt for any goods, documents, or computer equipment seized or detained during a search under this section to the owner or occupier of the premises or other place concerned. 9. A person shall not prevent an officer from gaining access to any premises or other place which that officer is entitled to access pursuant to a warrant issued under this section. 10. Notwithstanding subsection 5, the person in control of the premises or other place concerned is entitled to demand that an officer who seeks access thereto produce A, the officer's identification card referred to in section 277, and B, a warrant authorizing the officer to enter and search the premises or place, as the case may be. 11, if an officer, after having complied with a demand under subsection 10, is not immediately allowed entry to the premises or other place, the officer may use force to the extent necessary for the purpose of gaining entry in accordance with the warrant, including A, opening or breaking through where necessary, any entrance to the area, premises, or facility, or any door, window, room, enclosure, place, safe, chest, box, package, or container that is locked and in respect of which the keys are not produced on demand or otherwise not made available. B, breaking through any fence, wall, roof, ceiling, ground, or flooring. 12. A person exercising powers under a warrant issued under this section may secure from other persons such assistance as is reasonably necessary for the purpose of executing the warrant. 219. Access to means of transport. 1. An officer may stop and search any means of transport, A, within a customs controlled area, or B, on any road, if the officer has reasonable grounds to suspect that the means of transport contains any goods in respect of which a contravention of any customs law has been or is being committed. 2. An officer may, at any time for the purposes of this section, A, order the operator of a vessel, aircraft, or vehicle to stop or land as the case may require, or B, if necessary, force the vessel, aircraft, or vehicle to stop or land as the case may require. 3, a person who refuses to stop or land as the case may be, when required to do so by an officer under subsection 1 or 2, or to permit the search by an officer, commits an offense. 220. Clause 220, powers during search of premises or other place or means of transport. Subclause 1. When performing a search of any premises or other place or a means of transport to which an officer has gained entry in accordance with section 218 or 219, in exercise of a power of search, the officer A shall have access to every part of the premises or other place or means of transport. B, may rummage any part of the premises or other place or means of transport. C, may fasten down the hatchways of any vessel or mark, lock up, seal, or otherwise secure any goods or documents found in or at the premises or other place or means of transport. And D, may search in accordance with this subpart any person found in, on, or at the premises or other place or means of transport. Subclause 2. If any hatchways of a vessel have been fastened down, or any goods or documents have been marked, locked up, sealed, or otherwise secured under subsection 1C, a person shall not, except with the permission of an officer, open the hatchways. 2, open, break, destroy, alter, or in any way tamper with such mark, lock, or seal. Or 3, remove the goods or documents. And B, the person in control of the premises or other place or means of transport shall take all reasonable steps. Let me read that again. The person in control of the premises or other place or means of transport shall take all steps reasonable in the circumstances to prevent any contravention of paragraph A. A person who contravenes subsection 2A commits an offense. Clause 221. Stopping or calling on persons. Subclause 1. Subject to subsection 2, an officer may, at any time, for the purpose of enforcing any provision of this act or any other customs law, A, stop or call on any person, whether or not the person is located inside or outside a customs controlled area, and B, require the person to produce any items which the person, 1, is carrying, 2, has brought into Jamaica, or 3, intends to take out of Jamaica. 2, an officer may exercise the powers referred to in subsection 1A and B in relation to any person inside or outside a customs controlled area if A, the person is located at or in any premises or other place or in a means of transport to which the officer has lawfully gained access, or the officer has reasonable grounds to suspect that the person has, 1, any goods that are subject to customs control, in respect of which a contravention of this act or any other customs law is being or has been committed, or 2, any documents concerning A, any goods that are subject to customs control, in respect of which a contravention of this act or any other customs law is being or has been committed, or B, any activity which constitutes a contravention of this act or any other customs law. 3, if a person referred to in subsection 1 fails to stop when requested by an officer to do so, the officer may take such action, including the use of force, as is necessary in the circumstances to stop that person. Clause 222, search of persons. Subclause 1. Subject to the provisions of this section, an officer who has reasonable grounds to suspect that a person is carrying goods that are subject to customs control, in respect of which a contravention of any customs law is being committed, may search the person and any baggage carried by that person. 2, in the exercise of any powers under this section, A, a female shall only be searched by a female officer. B, a search that involves probing any orifice or cavity of the body shall be carried out only, 1, pursuant to a warrant issued by a judge of a parish court or justice of the peace, and 2, by a duly registered medical practitioner who, along with the person being searched, such medical assistance as are absolutely necessary in the circumstances, and the witness, if requested by the person being searched, shall be the only persons present during the search. C, every search shall be carried out in a place and manner that affords the person being searched reasonable privacy. And D, a search of an individual who is under the age of 18 years shall only be conducted in the presence of the person's parent or guardian or other person not being an officer, for the time being having the charge, care, or custody of that individual, unless such parent, guardian, or other person having the charge, care, or custody of the individual cannot be located through reasonable effort. I wish to pause here, Chairman, to raise to the committee a concern that had been raised by stakeholders. And in particular, the concern had to do with the provision that indicated that a female shall only be searched by a female officer. And the question had been raised in the context of persons who may identify with a gender that is other than their biological sex, and how that may raise concerns in the context of a search. And so it was.
Sorry, go ahead. You finish first.
Yes, Minister. And so it had been, there were a number of proposals that were put forward. When we had looked at the proposals, we weren't entirely satisfied that what was suggested by the stakeholder would resolve the challenge. And so if this is a matter that the committee is of the view that we need to go further than simply indicating that a female should be searched by a female, we had put forward the possibility of amending the provision to indicate that a person who is to be searched may have the be told of the option to indicate the gender of the person whom they wish to conduct the search. And if they indicate a preference and an officer, that gender of course is available, then the person will be searched by that person. But if no particular preference is exercised, then we would still maintain the provision that a female would only be searched by a female officer.
Suppose you had a female shall only be searched by a female officer, you know, but unless the person objects.
Well,
I think, Chairman, unless the person objects and states a preference, because you can't just object.
Right, states a preference. States another preference.
Yes.
Yeah. I don't know if you should go to the point where everybody, are you saying that one solution is to go to the point where everybody being searched has a choice as to which gender?
yes, but we recognize that it's a problematic approach. We're seeking to somewhat respond to the concerns that the stakeholder had raised. As we said, in the context of persons who identify, you know, a particular gender. Concerns were also raised about males who may be of a particular religious persuasion, for example, and they may object to being searched by a female. And so whilst the law had only sought to restrict it in the context of the females, whether we should also go further.
Okay, this can't be the only ones who have this issue. How is it resolved by jurisdictions that we pattern?
Well, there are a number of approaches. The approach in the revised Kyoto Convention, the recommendation there is that searches should only be conducted by officers of the same gender as the person being searched. And so the standard would be males by males, females only being searched by females. That is the approach recommended in the revised Kyoto Convention. Some countries have adopted that approach, and many countries have adopted the approach that we have indicated here in terms of specifying for females, but leaving it open for males.
Anybody in the committee has a view?
No, and Chairman, it seems to me that you know, I think in the current dispensation, if someone has made a preference as to which gender they become, and they state that preference, I would imagine that at our ports now, if you put that provision in, then it can't just be all male or all females on duty at any one time. You'd have to have consideration for that mix that has been stipulated in the law. And the gender, I'm not sure I don't think the person get to nominate a third gender. I don't know that we are there yet, but it's a male or female, and I think that should be what is provided. The person can change their sex and ask for and state a preference, but I don't know if a third gender. It's still male and female.
At the moment, our law, correct me if I'm wrong, lawyers among us, but our law recognizes two genders, right?
Yeah, and even if it's trans, it's trans in a certain direction. So it's two genders.
Chair, my only thought would be to ask the question, what is done in other jurisdictions, like the UK and the US, etc., to give us some sort of a guide of how they have handled this, what Heather has referred to quite correctly as a very sensitive issue.
But turn that question over to Customs. Her response on the Kyoto protocols, Kyoto just recommends, searches to be consistent on gender. Male search males, female search females. But anybody would be able to say what happens in jurisdictions such as the UK or Canada?
That can be found out. Best practice in states that we emulate from time to time, I think, is the response.
Yeah.
Chairman, I'm not able to recall at the moment. I know we had looked at several countries. I'm not able to put my hand on the document that deals with the position in the UK and in the US. I would just ask that you give us an opportunity to just come back to you on that. But I know that we had looked at several countries.
Yeah. We have a growing list of things that we're going to look at. We might have to have an entire 3-hour meeting to go over those list of things that we are going to look at again. But I don't think that we can short circuit this one by finalizing a position without taking on the suggestion of Senator Webby of just having a matrix or, you know, what other countries that we often emulate, what provisions they have in this regard. So let's move on. And if you could do that background research for us to consider, again, not at the next meeting. We want to put all of these issues, you know, to the end when we've gone over the bill, and there'll be maybe between, you know, 15 or 20 things that we're going to come back and consider once again.
Noted, Minister, and also, Chair, just to note that a stakeholder had made a recommendation in relation to an express provision to indicate that officers should be empowered to utilize aids during searches. And that was our recommendation that we had indicated that we would be minded to take on board, and with a further indication that regulations be developed regarding the use of such aids.
When you say aids, what do you mean?
Such as chemical substances, imaging equipment, dogs, so on.
Right. Okay.
Particularly the chemical substances and the imaging equipment.
Right. Okay.
Which is routine.
Yes, routine.
Part of searches these days.
All right, continue, please.
Yes. Clause 223. Exclusion of liability for searches. The Commissioner and every officer acting in the exercise of a power of search in accordance with the provisions of this subpart shall not be held liable in connection with the search on the grounds that no evidence of the commission of an offense was found during the search. Clause 224, inspection of goods. Subclause 1. An officer may inspect A, any goods within a customs controlled area or in or on any premises or other place or any means of transport within a customs controlled area. B, any goods in the possession of a person within a customs controlled area. C, any goods found during a search under this subpart of 1, any premises or other place or means of transport, or 2, any person. D, any goods on public display for sale. E, any goods produced on request by an officer under this subpart. F, any goods in respect of which the officer has reasonable grounds for suspecting that a contravention of this act or any other customs law has been committed. Or G, any goods that are subject to customs control. Subclause 2, subject to the requirements of Section 218, power of entry and search, goods referred to in subsection 1 may be inspected at any time without prior notice to any person. Subclause 3, an officer may request any person selling, offering for sale, or otherwise dealing in, processing, or transporting imported goods, A, to produce the goods or make the goods available for inspection, either immediately or at a time and place specified by the officer. B, if the person is the declarant in relation to a goods declaration registered under this act, not more than 7 years prior to the date of a request under this subsection in respect of those goods, to produce proof of 1, a declaration for customs procedure. 2, payment of the duty and tax applicable to the goods. 3, in the case of goods for commercial use, the marks and numbers of the packages or containers in which the goods were imported. And 4, compliance with any other requirements of the customs laws relating to the goods. C, if the person is not the declarant referred to in paragraph B, to disclose the name, address, and other contact details of the person from whom the goods were obtained. 4, if an officer has reasonable grounds to suspect that a person referred to in subsection 3 is concealing A, any goods or information which that person was required to produce under that subsection, or B, any goods in respect of which a contravention of this act or any other customs law is being or has been committed, the officer may search that person in accordance with the provisions of section 222, subsection 2. 5, a person who fails to comply with a request made to that person under subsection 3 commits an offense. Clause 225, inspection of documents. Subclause 1. Subject to the requirements of section 218, power of entry and search, an officer may inspect A, any documents, 1, found during a search under this subpart of any premises or other place or means of transport, 2, produced to the officer pursuant to a request under this subpart, or 3, that relate to any act or omission which the officer has reasonable grounds to suspect constitutes a contravention of this act or any other customs law. D, any documents that relate to 1, any premises or other place or means of transport within a customs controlled area, 2, any premises or other place or means of transport searched under this subpart, 3, any goods within a customs controlled area, including any goods in, on, or at any premises or other place, or in a means of transport within a customs controlled area, 4, any goods found during a search under this subpart of any premises or other place or means of transport, 5, any goods produced on the request of an officer under this subpart. 6, any goods in respect of which the officer has grounds to suspect that a contravention of this act or any other customs law has been committed, or 7, any other goods that are subject to customs control, and C, any records that a person is required to keep or produce under this act or any other customs law relating to goods to which this act applies. 2, the power to inspect documents under this section includes, to the extent necessary for the enforcement of this act or any other customs law, A, examining the documents, B, copying or making extracts from the documents, C, making audio or video recordings of the documents, and D, removing the documents in order to make copies, extracts, or recordings, or in order to carry out further examination of the documents. 3, an officer who removes, 3, an officer who removes documents pursuant to subsection 2D shall A, provide in the form prescribed by rules a receipt for the document. And so it's in that context and for this particular purpose that we're recommending its removal. But we would still retain the provision, well, certainly it is still there, that the civil proceedings for the recovery of duties and taxes and charges and fees must be commenced within 7 years.
I was just looking at an existing, I don't know if I'm reading it, in 239 of the existing act.
239 Minister?
Yeah.
Or Yes, Minister, there is that provision there. You are correct. I was thinking that you were referring to section 241, but I see that you're referring to 239.
Mm-hmm. So yeah. So your point is that these are criminal offenses and the law is moving in the direction of not having a limit?
Well, no, Minister, I'm aware that there have been discussions around that, having a limit. I'm not sure if law reform is here, but I know that those discussions have been happening. I'm not sure where those discussions have reached, but certainly when we were preparing this legislation, we're aware that those discussions were happening.
I would have to be further advised on that. I mean, this is what exists now. And, you know, to change it, I would need some further advice from, you know, people in the legal fraternity, AG's chambers, etc. Any comment on this from the AG's chambers?
Noted, Minister, we will consult again with
the principles behind a change are big principles. I don't want to, I would need to, I definitely need more advice on that. Okay.
Noted, Minister. We will also consult again with law reform on the issue.
Yes, in particular law reform. That's what we don't want to hear from on that.
Can I make a comment before, Chairman, before Ms. Edwards moves on?
Please do.
Ms. Edwards, could you go back down to the arrests? I note, remember Hilton concerned earlier with regards to justice of the peace, and I accepted the position, Ms. Edwards, of yourself and others in the explanation. But in this particular case where a person is going to be arrested, I think the section said, I'm not seeing it here right now. I think the thing is in front of it where it says it's going to be taken before a judge of a parish court or a justice of the peace to be dealt with according to the law. Would the seriousness of the offense here requires a greater interrogation by a parish court rather than a justice of the peace? Just asking. Or you're just trying to be consistent with all the other sections that indicate that justice of peace is almost given the same recognition as a parish court judge? Ms. Edwards?
Well, I believe the question really turns on the powers of the Justice of the Peace under the Justice of the Peace Jurisdiction Act. And there we see that it is possible to confer power under other enactments on the Justice of the Peace to deal with certain matters. And even under the provisions of the current Customs Act, there are some matters that the Act does indicate can be dealt with by a Justice of the Peace. For example, a breach of Section 210 currently of the Customs Act, which has to do with the importation of prohibited goods. All right, importation of prohibited goods or the importation of restricted goods without complying with the restriction. Similarly, provisions dealing with the evading of customs, of import or export duties, concealing prohibited, restricted, or uncustoms goods, fairly serious offenses. And there is a provision there for, well, obviously there's a monetary limit, but there is a provision there for some of those matters to be dealt with by a Justice of the Peace. But I can appreciate the point that here there's no distinction as to what types of matters would go before the Justice of the Peace and which ones would go before the parish court. So am I to understand that you are, in not seeing that clear distinction, you are concerned as to whether the justice of the peace would be dealing with matters that it would not be appropriate for the JP to be handling?
Yeah, with regards to this particular clause, yeah, not the ones before, but
Not
just
the ones before, but
the
this
one
one.
after this period of time, etc.
If I may add something, Mr. Edwards? Chairman?
Go ahead, please.
Right, so member don't except for murder, I think, under the Bail Act, when somebody's been arrested, they can be taken before a jury.
Was that Peter Simmons a while ago? I didn't have my portal up. Who?
Chairman, I saw Judith Grant, her hand was raised.
CPC, please go ahead.
Thank you, but I was just gonna raise up the same point as Mr. Lowe, that reference there, I think primarily has to do with bail. In that case, the Justice of the Peace is empowered to conduct the necessary hearing.
Right. Okay. Thank you for that, CPC. There was a comment in the chat from Peter Simmons on 213. This is a few clauses ago. 213.6b and 7 re-servicing of what constitutes adequate service. You want to expound on that?
The comment relates to clause 213 or 230?
Yeah. 13, which is 20 clauses
13?
ago. We'll come right back. 6b and 7b. 213, 6b and 7b.
Two 13, 6b. Six B and 7, and the question related to
7b. The comment was that personal service can only be service on the person intended. Any other method of service is an alternative method of service which must be deemed adequate to come to the attention of the person to be served. Service on an adult person employed to the person to be served is not necessarily adequate. The court may well deem service on any adult person to be inadequate, even where service is on such an adult person, especially in cases where the person to be served is not in fact aware of the service. The Customs Act should not depart from the civil procedure rules of the court. He's right. What he says, his microphone and camera aren't working. So he put it in the chat. So he's saying what we have there in that 6b, that it is to be considered lawful, it will be considered lawful means of service if and to be validly served if it's left with an adult person employed at the place of the business. So this just seemed that we just need to consult on the 6b and 7b here, just to make sure that we are consistent with the most up-to-date civil procedure rules of court.
Noted, Chairman, we will do a review to see what adjustments, if any, are required.
And thanks to Peter Simmons for making that comment in the chat. All right, back to 231, was it? Or 232?
232.
Yeah.
Thank God for technology.
Clause 232, arrest of person on the authority of warrant. Subclause 1, where an officer has reasonable cause to suspect that a person has committed an offense against any customs law, the officer may apply to a judge of a parish court or a justice of the peace for a warrant authorizing the arrest of that person. 2, where an officer knows or has reasonable cause to suspect that a person who is liable to be arrested under any customs law is located on any premises, the officer may apply to a judge of a parish court or a justice of the peace for a warrant to enter and search those premises and effect the arrest. 3, a warrant of arrest issued by a judge or justice under subsection 1 or 2 may be executed by an officer. 4, a person arrested under this section shall be brought before a judge of a parish court or justice of the peace to be dealt with according to law. Clause 233, non-liability for wrongful arrest. Subclause 1, an officer who, in the reasonable belief that the officer is arresting a specific person, arrests another person, is not liable for wrongful arrest unless it is established that the officer acted maliciously in making the arrest. Subclause 2, a constable, an officer, or any other person who assists an officer in making an arrest or who is required to detain a person so arrested and who reasonably believes that the person is the person who is to be or has been arrested in accordance with section 231 or 232 shall not be liable if the arrest is wrongful, unless it is established that the person acted maliciously in assisting the arrest. Subpart D, carrying and use of arms and ammunition. Clause 234, use of firearms. Subclause 1. The commissioner may issue to an officer any of the following items. A, subject to the provisions of the Firearms Act, an official firearm and ammunition. B, non-lethal weapons for the purpose of exercising the officer's functions under this act, and an officer to whom any such item is issued shall be entitled to carry that item. Subclause 2, the commissioner may, after consultation with the minister responsible for national security and subject to the Firearms Act, establish an armory, appoint an armorer, and assign that armorer such functions and duties as are required for the purposes of the customs laws. Subsection 3, the commissioner shall, in accordance with the general directions of the minister responsible for finance, provide an account to the minister responsible for national security in respect of the armory, and after considering the account, the minister responsible for national security shall take such action, if any, as that minister considers appropriate. Subpart E, detention, seizure, and confiscation of goods. Clause 235, power to detain goods. 1, an officer may detain goods under customs control or documents relating to such goods, A, for the purpose of investigating or determining whether, 1, a contravention of this act or any other customs law has been committed. 2, the goods are to be excluded or exempted from a requirement of this act or any other customs law, or are goods in respect of which an authorization or other special dispensation applies. 3, the goods are prohibited or restricted goods and are dealt with in contravention of any law. Or 4, the goods have been or are being used in the commission of an offense against a customs law. B, if the detention of the goods or documents is permitted by any other law. Or C, in such other circumstances as may be prescribed by regulations subject to affirmative resolution. 2, upon detaining goods on...
Sorry, Mr. Edwards. For at the top, the goods have been or are being used in the commission of an offense?
Have been or are being used, yes.
In the commission of an offense. commission or committing commission?
I defer to CPC in relation to that. It seems I don't have any challenges, but I defer to CPC. Are you suggesting, Member Dunn, that perhaps it should be used in committing an offense?
No, you see, I don't know because I'm not. I mean, as I rightfully did defer to CPC.
Right. I have no difficulties.
Okay. Okay.
I'll just defer to perhaps. I would only perhaps wish to raise a concern at C, in that these regulations identifying the circumstances, the types of goods that or the circumstances under which goods may be detained, that these regulations are subject to affirmative resolution. And it seems to the technical team on further review that this is quite higher standard, having regard to the nature of these types of regulations, and that perhaps it is sufficient for the provision merely to indicate prescribed by regulations and to delete the words subject to affirmative resolution. And so we will put that for the consideration of the committee, that we're not here imposing a tax or so. We are sensitive to the fact that we are dealing with the detaining of goods, and that has an impact on the citizen. And so it is indeed appropriate that those the circumstances for detention be prescribed in regulations. But we consider on further review that it is perhaps unnecessary for those regulations to be subject to affirmative resolution.
Okay.
All right. Subclause 2. Upon detaining goods under subsection 1, the officer shall issue a notice of detention to A, the declarant, or if there is no declarant, the importer or exporter, as the case may be, and B, the person in whose custody the goods are or are believed to be at the time of detention. Subclause 3. Subsection 2 does not apply to a person who is unknown or cannot be located through reasonable effort. And in that case, the officer shall affix the notice to a conspicuous location at the place where the goods are detained. Subclause 4. If goods are detained under this section while the goods are at a customs controlled area, the commissioner shall issue a copy of the notice of detention to the operator of the customs controlled area. And subclause 5, a notice of detention under subsection 1 shall be in the form prescribed by rules. Clause 236, inspection of detained goods. 1. Before inspecting goods that have been detained under this subpart, an officer shall A, notify the declarant of the date, time, and place for the inspection, and that the declarant may opt to be present at the inspection, or B, require the declarant to be present at the inspection by notice in writing stating the date, time, and place for the inspection. 2. An officer may inspect goods detained under this subpart in the absence of the declarant if A, the declarant fails to attend the inspection at the date, time, and place specified in a notice under subsection 1, or B, subsection 3 applies. Subsection 3. An officer may dispense with the requirement for a notice under subsection 1 and proceed to conduct an inspection of goods if the officer is satisfied that giving notice of the date, time, and place for the inspection would prejudice A, an investigation into an offense under this act or any other law, or any interest of national security or public health, or B, the exercise of the commissioner's function under this act or any other law. Clause 237, termination of detention, subclause 1. Where goods are detained under this subpart, but the grounds for the detention no longer exist, or 12 months have elapsed since the date of the detention, the commissioner shall A, either seize or confiscate the goods, if reasonable grounds for such seizure or confiscation exist under this act or any other law, or terminate the detention of the goods. B, notify the declarant of the action taken under paragraph A, and C, if the goods are kept at any premises that is not a customs control area, the commissioner shall also notify the owner or occupier of the premises of the action taken under paragraph A. Subclause 2, notwithstanding A, the time specified for review or appeal under subpart C of part 11, and B, that the time allowed under subsection 1 has not elapsed, where no action is taken under subsection 1A within 90 days, after the date of the detention, the declarant, or if there is no declarant, the importer or exporter, as the case may be, may at any time while the goods remain detained, apply for review or make an appeal in accordance with subpart C of part 11 against the detention. CPC, I'm just confirming that the where no action should go back to the margin.
Something seems wrong with her microphone. We're not.
Yeah, sorry. Can you just remind me where you are?
Just looking at clause 237, subclause 2B. I suspect that's a printing matter in terms of the where, that the words where no action should go back to the margin, perhaps.
Yeah, there are some words that go back to the margin. I just have to confirm from where, but yes.
Yes, all right, very well. Clause 238, power to seize goods. Subclause 1. The commissioner may seize any goods detained under this subpart A, if the goods are liable to confiscation under this act or any other customs law. B, if the goods are or may be needed as evidence in any criminal proceedings under the customs laws. C, if the seizure of the goods is otherwise permitted under this act or any other law. Or D, in such other circumstances as may be prescribed by regulations. 2, goods seized under this section shall, for the duration of the seizure, be stored in accordance with section 242. Clause 239, notice of seizure. 1. Upon seizing goods under section 238, an officer shall issue a notice of the seizure, A, in the case of goods that were detained under section 235 at the time of the seizure, to the person to whom the notice of detention was issued. B, in the case of goods other than goods referred to in paragraph A, to 1, the declarant, or if there is no declarant, the importer or exporter, as the case may be, and 2, the occupier of the premises where the goods are located at the time of the seizure. Subclause 2, subsection 1B shall not apply to a person who is unknown or cannot be located through reasonable effort. And in that case, the officer shall affix the notice to a conspicuous location at the place where the goods are seized. 3, a notice under subsection 1 shall be issued in the form and subject to subsection 2 in the manner prescribed by rules, and shall state the quantity and the description of the goods seized. Clause 240, termination of seizure. 1. The declarant in respect of goods seized under this subpart, or if there is no declarant, the importer or exporter, as the case may be, may apply to the commissioner for termination of the seizure. 2. An application under subsection 1 shall A, state the reason why the seizure should be terminated, and B, be made in such form and manner as may be prescribed by rules. 3. So clause 3. Upon considering an application under subsection 1, the commissioner may grant the application subject to such conditions as the commissioner considers appropriate for compliance with the customs laws in respect of the goods, or refuse the application. 4. Subject to subsection 5. If an application under this section is granted, the applicant shall pay to the commissioner A, all duty, tax, charges, and penalties due to the commissioner in respect of the goods, and B, any expenses incurred by the commissioner in respect of 1, the seizure, and 2, if the goods were detained under section 235 before the seizure, the detention of the goods. Subclause 5. Where an application under subsection 4 is granted because there were no grounds under this part for the seizure, the applicant shall not be liable to pay the expenses referred to in subsection 4B. 6. The commissioner shall notify the applicant A, if the application under subsection 1 is granted, of the termination of the seizure, or B, if the application under subsection 1 is refused, of the refusal and the grounds therefore. 7. A copy of the notice given under subsection 6A shall be given to the occupier of the premises on which the seized goods are kept. Clause 241. Application for confiscation upon refusal to terminate seizure. Notwithstanding section 199, where an application for review is made or an appeal is brought against the decision of the commissioner to refuse an application for the termination of a seizure, the commissioner may apply to the court for an order for the confiscation of the goods. 2. The commissioner shall A, give notice of the application under subsection 1 to 1, the declarant, or if there is no declarant, the importer or exporter, as the case may be, and 2, the occupier of the premises where the goods are located at the time of the seizure, and B, publish a notice of the application in a daily newspaper in circulation throughout Jamaica, and may also publish the notice using such other means as the commissioner considers appropriate to bring the application to the attention of the public. 3. Subsection 2A2 shall not apply to a person who is unknown or cannot be located through reasonable effort. And in that case, the officer shall affix the notice to a conspicuous location at the place where the goods are seized. 4. Where an application for the confiscation of goods is made under subsection 1, any person who claims an interest in the goods may, before the confiscation order is made, apply to the court for an order under subsection 5, showing cause why the confiscation order should not be made. 5. On an application under subsection 4, the court shall make an order declaring the nature, extent, and value, as at the time the order is made, of the person's interest in the goods, if the court is satisfied, A, that the person was not in any way involved in the commission of the offense on which the seizure was grounded, and B, where the person acquired the interest during or after the commission of the offense, the person acquired the interest, 1, for sufficient consideration, and 2, without knowing or having reasonable grounds to suspect that at the time the person acquired the interest, the goods were connected with the offense. Subsection 6. Subject to subsection 7, where a confiscation order has already been made under this section, a person who claims an interest in the goods concerned may, before the end of a period of 60 days commencing on the day on which the confiscation order is made, or such a longer period as the court may allow, having regard to all the circumstances, apply to the court for an order under subsection 5. Subsection 7. A person who, A, had knowledge of the application of the confiscation order before the order was made, or B, appeared at the hearing of that application, shall not, except with the leave of the court, be permitted to make an application under subsection 6. 8. Where a person has obtained an order under subsection 5, and the period allowed by rules of court with respect to the making of appeals has expired, the minister shall direct that A, the goods or the part thereof to which the person's interest relates be promptly returned to the person within 96 hours, or B, an amount equal to the value of the person's interest as declared in the order be paid to the person. In this section, court means the parish court for the parish in respect of which the goods are seized. Clause 242, storage of detained or seized goods. 1. Goods detained under section 235 or seized under section 238A may, pending any action that may be taken in respect of the goods, be kept at the place where they were detained or seized, as the case may be, or be stored at any premises or warehouse, as the commissioner may direct. And B, in the case of goods that are perishable, shall be stored in accordance with rules. 2. A person shall not remove goods from the place where they are kept pursuant to subsection 1, unless the commissioner so permits. 3. If the place where goods are kept pursuant to subsection 1 is not a customs controlled area, the commissioner shall, for the purposes of this act, have the same access and powers in respect of those goods as if that place were a customs controlled area. 4. A person who contravenes subsection 2 commits an offense. Clause 243, confiscation of goods. 1. Subject to subsection 3, the commissioner may confiscate A, any goods in respect of which an offense against this act or any other customs law is committed, in respect of which proceedings are stayed by virtue of section 254(5). B, any goods that are required to be destroyed or otherwise disposed of in order to give effect to a provision of this act or any other customs law. C, any item, including any means of transport that has been specially constructed, adapted, altered, or fitted in any manner for the purpose of concealing goods subject to customs control in a manner calculated to deceive an officer. D, any document in respect of which an offense falling within paragraph A has been committed or which relates to such an offense. E, any goods imported contrary to any restrictions or conditions imposed under any law or that are required to be confiscated under any other law and which the competent authority has directed the commissioner to confiscate. Or F, any prohibited goods. In this section and sections 250 and 251, competent authority means the appropriate government authority responsible for regulating the prohibited or restricted goods concerned. 3, the commissioner may confiscate any goods referred to in subsection 1, which were seized pursuant to a power under this subpart A, if after the expiration of 60 days after the date on which the goods were seized, no application for termination of the seizure is made under Section 240, or B, if an application for termination of the seizure has been made but has been refused, and no application for review or appeal against the refusal has been made within the time allowed under Subpart C of Part 11. Where an application for review or an appeal is made against the refusal of an application to terminate a seizure, the Commissioner shall act in accordance with Section 241. 5. The Commissioner shall give written notice of the confiscation of goods under this section to A, in the case of goods seized under Section 238, the person to whom notice of the seizure is required to be given, and B, in any other case, the declarant, or if there is no declarant, the importer or exporter, as the case may be, or the person in possession of and who appears to be in possession of the goods at the time of the confiscation. Sixth, goods confiscated under this section become the property of the Crown. Clause 241, withdrawal of confiscation. Subclause 1, the Minister shall direct the Commissioner to return any goods if the goods were confiscated in error. 2, where goods are directed to be returned, under subsection 1, the Commissioner shall notify A, all persons to whom notice of the confiscation was issued, and B, if goods confiscated under this subpart are kept at any premises, the owner or occupier of the premises. Clause 245, disposal of confiscated goods. Goods confiscated under this subpart shall be disposed of in such manner as the Minister may prescribe. Subpart F, prohibited and restricted goods. Clause 246, power to prohibit importation, etc. of goods. Subclause 1, the Minister may, by order published in the Gazette, prohibit absolutely the importation, exportation, or carriage coastwise of A, goods of any kind specified in the order, or B, goods of any kind to or from any particular place outside Jamaica named in the order. The following goods are prohibited goods for the purposes of this Act. A, any goods imported in contravention of any law prohibiting the importation of those goods, and B, any goods in the process of being exported in contravention of any law prohibiting the exportation of those goods. 3, a person who imports or exports.
Chairman, a question.
Please go ahead.
So query, in respect of the preceding provisions, is this not, does the Minister act without reference to any obligation in CARICOM, for example?
Can you be a little more specific? You're talking about like where it says,
just go back up. The specific order, the Minister may prohibit goods. Right, so we may order by simple published prohibit absolute importation, exportation of or carriage coastwise, really goods of any kind specified in the order, or goods of any kind or form in a particular or from in a particular place outside of Jamaica. The goods prohibited goods for the purposes of this Act, in the goods imported in the law prohibited goods is good, and the goods in the process of being exported in contravention. The question there is that this is this are the prohibition grounded on any health, or what is the basis for the prohibition? Just so, what's the basis for the prohibition?
If I'll give you a more thoughtful response in a second, but my gut response is that we retain ultimate control of our borders, right? Even though we are also party to treaties and so forth. I think what this allows for is allows the legal avenue for emergency situations.
Well, it's not saying so. So I mean, so my question is, where you have your treaty obligation, especially in a context where you have a single market arrangement, does the minister? I mean, I can understand health and national security kinds of foundation, but I mean, it's not clear. It's not coming clear to me what is the basis for that action. And yes, the borders are you have control over your borders, but your actions are also prescribed by treaties that you've undertaken. Treaty obligation that you're undertaking. So I would just want to make sure that that is consistent with our other legal and treaty obligations, particularly treaty obligations.
Indeed, member, it is anticipated that when the minister is exercising this power, the minister will have regard to all the relevant matters, including any international obligations that Jamaica has and any obligations that we will have to our regional partners. But this is a power properly vested in the executive minister, and so it will be necessary for the minister from time to time to prescribe that there are certain goods that cannot be imported. And in fact, we have treaty obligations that may require us to prohibit the importation of certain goods. This is
that's clear. That's clear. That instance, that's very clear. I mean, I'm talking about accepting those situations and for national security, health kinds of consideration. I'm just, anyway, please ensure that that is so, because it seems very broad to me.
It may be broad, member, but I would only want to indicate that it actually reflects a power that the minister now has in the Customs Act, and to also indicate that the minister with responsibility for trade has a similar type of power under the Trade Act.
But I just again, I'm recalling that this act was from before independence. I mean, some things have changed, and the fact that it is in the act previous, I mean, doesn't answer my concern.
It's not so much that it's the act previously, it's in the act now. This is a general rule where acts give ministers power to act. It is expected that the ministers will exercise that power lawfully. And lawfully in this case would be with regard to the international laws that we are a part of. It's not, if you were to go around and everywhere it says the minister has the power to do X and Y, if you were to list all of the laws that the minister has to comply with in order to fulfill that function, you wouldn't have enough space. So as a general rule, the expectation is where you have that the minister has this power, which exists today, that power exists right now, whoever is minister, the expectation is that it will be exercised lawfully. And if it's not exercised lawfully, then
what?
There's recourse.
Yeah,
recourse. I mean, you can't, it's the nature of...
I understand the point you make. I understand the point that you're making. I've with respect to the subject matter that we're dealing with, which is really an economic arrangement. That if your CPC and the Attorney General Chambers have thought that, and that is really just an art, a form of drafting regulation, well, so be it. But I just want to make sure that there's been a reflection on that point.
Yes.
Okay. We may proceed.
Thank you. Thanks, member. We have 10 minutes to go. And again, I don't want to detain everybody. This is really, a dense piece of legislation, but if I must say so, thanks to the work that has gone into it, it's taken years of consultation just to get to the stage where we are here, and it's been redrafted several times, which and in everyday language, which is great. But I know it's hard going on members and those who have to kind of sit through. So I don't plan to detain you for much longer, but I'd like to kind of set a logical goal. We are at 2:47 now. Whoa, no, we cannot finish this.
2:52.
You think we could get there? Let's try.
We'll try. Clause 247, savings for transit goods and stores. Goods under a transshipment, transit to export, or stores procedure shall not be treated as prohibited goods under this subpart, unless the import or export of those goods under the transshipment, transit to export, or stores procedure is expressly prohibited by any regulations made under this act or by any other law. Clause 248, restricted goods. 1. Any goods that may only be imported into or exported from Jamaica in accordance with conditions or restrictions imposed by law are restricted goods for the purposes of this act. 2. The minister may, by order published in the Gazette, specify in relation to A, goods of any kind specified in the order, or B, goods of any kind intended to be imported, exported, or carried coastwise to or from any particular place outside Jamaica named in the order, the conditions which shall be required to be met for the goods to be imported, exported, or carried coastwise. Clause 249, clearance of prohibited goods and restricted goods. 1. No person shall clear prohibited goods for a customs procedure. 2. No person may clear restricted goods for a customs procedure unless A, that person submits to the commissioner an authorization for the import, possession, or export of those goods, or B, the authorization referred to in paragraph A is issued or confirmed electronically by the competent authority for issuing the authorization in such manner as the commissioner may direct. 3. Notwithstanding subsections 1 and 2, but subject to subsection 4, imported prohibited or imported restricted goods destined for a place other than Jamaica may be cleared for transshipment, transit to export, or as stores. 4. Imported prohibited or imported restricted goods shall not be transshipped or placed under the transit to export procedure or the stores procedure in circumstances where the import, export, or possession of such goods is prohibited or restricted by any law, the purpose of which is to A, combat illicit trade in narcotics or arms and ammunition or endangered species or any other items prescribed by regulations. B, combat the spread of contagious human, animal, or plant diseases. C, protect the public against hazardous substances. D, protect public health or safety. Or E, give effect to any international obligation binding on Jamaica, except in accordance with the applicable provisions of that law. Perhaps back to the margin there again, CPC. Let's accept. 5, A person who attempts to clear goods in contravention of this section commits an offense. Clause 250, detention of prohibited or restricted goods. 1. Subject to subsection 2, the commissioner shall detain, in accordance with section 235, any prohibited or restricted goods imported or in the process of being exported in contravention of A, any law, or B, any term or condition imposed under any law. 2. The following goods are excluded from detention under subsection 1. A, imported, prohibited, or restricted goods that are cleared under section 249.3 for transshipment or transit export or as stores if the goods are 1, dealt with strictly in accordance with the provisions of this act relating to that procedure, and 2, exported from Jamaica within the period applicable to those goods in accordance with that procedure. B, prohibited or restricted goods that are on board a foreign-going means of transport when the means of transport enters Jamaica, if those goods are destined for a place other than Jamaica and remain on board that means of transport until the means of transport leaves Jamaica. And C, prohibited or restricted goods that are on board a foreign-going means of transport when the means of transport enters Jamaica as stores for that means of transport if those goods, 1, are declared under section 50, 2, are not offloaded in Jamaica, and 3, are used or exported from Jamaica on board that means of transport as stores for that means of transport, unless the goods are goods referred to in section 249.4. 3. The commissioner shall promptly terminate the detention of goods under subsection 1 if A, the goods were detained in error, or B, the competent authority requests the commissioner to terminate the detention of the goods, unless the commissioner, you just need to add an ER there, unless the commissioner has other grounds for detaining the goods under this act. 4, subject to subsection 5, the commissioner may, A, on application by the declarant, or if there is no declarant, the importer of prohibited or restricted goods detained under this section, terminate the detention of the goods and allow the applicant to clear the goods for outright export and immediately export those goods from Jamaica at the applicant's expense and under the supervision of the commissioner. B, on application by the person who intended to export prohibited or restricted goods that were in free circulation before being detained under this section, terminate the detention and allow the goods to revert to free circulation. 5, the commissioner may grant an application under subsection 4 only if the applicant submits proof to the commissioner in the manner prescribed by rules that the competent authority does not object to the application. Clause 251, the disposal of detained, prohibited, or restricted goods. 1, goods detained under section 250 shall be dealt with in accordance with, as the case requires, A, the law under which the goods are prohibited goods or restricted goods, B, the law regulating criminal proceedings in respect of those goods, if and to the extent that the goods are needed as evidence in any criminal proceedings, or C, if the competent authority requests that the commissioner dispose of the goods and the commissioner accedes to the request in accordance with that request. 2, for the purposes of subsection 1C, the commissioner, A, may impose conditions as to costs or otherwise in acceding to a request, and B, shall confiscate the goods in accordance with section 243. 3, prohibited or restricted goods referred to in subsection 1A or B shall be handed over to or kept under customs control for the purposes of the competent authority. 4, subject to subsections 3 and 5, a competent authority shall be responsible for the removal and disposal of prohibited or restricted goods detained under section 250. 5, prohibited or restricted goods, A, imported, or in the process of being exported in contravention of any law referred to in section 249(4) shall be dealt with in the manner provided for in that law. Or if there's no provision in that law providing for the manner in which those goods shall be dealt with in the event of unlawful importation or exportation, as the case may be, then in accordance with the directions of the competent authority concerned. Or B, in any case where paragraph A does not apply, shall be detained or confiscated under this section unless required under subsection 3 to be handed over or kept, and shall be disposed of in accordance with the directions of the minister and subject to the following principles. 1. In the case of goods referred to in section 246(2)(a) or 249(4), the goods shall be destroyed or otherwise disposed of in a way that would not allow the goods into free circulation in Jamaica. 2. In the case of goods referred to in section 246(2)(b), the goods shall be disposed of in an appropriate manner, which may include A, destroying the goods, or B, exporting or re-exporting the goods. 6. Where prohibited or restricted goods are detained, confiscated, destroyed, or otherwise disposed of under this act or any other customs law, the commissioner shall be entitled to recover all the expenses related to such detention, confiscation, destruction, or disposal from A, the declarant, or if there is no declarant, the importer or exporter of the goods, and any agent liable for the goods under section 240. Clause 252, effect on other laws relating to prohibited or restricted goods. Nothing in this subpart shall be construed as affecting the application of any other law prohibiting, restricting, or controlling the importation, possession, or exportation of goods to the extent that this subpart is inconsistent with that other law. Minister, Chairman?
Yes.
I wish to just highlight a few things from the provisions that we just read very briefly. Just to indicate, for example, indicate at clause 250, subclause 4, there are provisions there for persons who may have imported goods, prohibited or restricted goods without complying with the restriction to actually apply to have those goods re-exported. And similarly, we see at clause 251, subclause 5, that there are provisions there for the minister to direct that those goods be exported. And the reason those provisions were put in is that in some instances, the destruction of the prohibited or the restricted goods may not be possible in Jamaica or may pose environmental harm. And so this allows a clear mechanism for those goods to be sent out of the country to be handled. And it also allows a means by which persons may have brought in a prohibited item without being aware, and they're able to sell the goods overseas. And this may provide an avenue for them to do so, while of course ensuring that Jamaica is not left with the burden of seeking to find a way to dispose of those goods. And in many instances, we are unable to, or we don't have the resources readily available. You will also notice from these provisions that the competent authorities have a key role in giving instructions to customs as to how they wish these regulated items to be handled. And that was done in response to the feedback that was received during the consultations with these competent authorities, and really duly recognizing the importance of their role. And a final matter I wish to highlight is that you will notice that the provisions, and here now I'm referring to clause 249, that there is a provision there for the minister for persons who are importing these items to either produce the relevant authorization from the regulatory authority, or there's a provision there that the commissioner may obtain the authorization directly from the competent authority electronically. And this is foreseeing where customs intends to go and has been going, where there's integration between the customs systems and the systems of the regulatory authorities. And that allows for more efficient processing relating to these goods, but it also significantly reduces the risk of fraudulent permits or licenses being used in the customs processing of goods.
Also, Minister, just to say that the concerns I raised earlier, I think I've seen various provisions, at least 2 provisions that seems to address those concerns. So I'm okay, I'm good.
Oh, thank you for pointing that out. Appreciate that. Okay, members, thank you again for your presence this afternoon and for your participation. We, just in terms of the date and the time for the next meeting, we had, I believe, scheduled the next meeting for next week. Is that correct? Next Thursday?
Yes, Chairman.
And that would be the
15th.
Let me just double check something here.
It would be the 15th, Chairman.
Okay, great, wonderful. All right, is there any other business that anyone wants to raise? Well, if there's no other business, let me thank all the members of the Joint Select Committee, thank members of Jamaica Customs Agency, the Attorney General's Chambers, CPC, Ministry of Finance, Ministry of all of those sort of connected with this bill. Thank you for your presence this afternoon and for your participation. It's a tough one, but we're making a lot of progress and look forward to your continued participation next week. Thank you all very much.
Thanks, Chairman.
Thank you, Minister.
Motion
Have
for
a good afternoon.
proposed
Good
draft
afternoon, everyone.